All right. How many people got caught by the train today that was stopped on the tracks? Oh, yeah. So, you know what I've learned? Well, I always know it. You just need to be patient. So, but all right. So I'm going to call the docket. DeJanette Havana,
Present with counsel, Your Honor.
Antavius Cifuentes, Rodney Brown. All right. And are you all here for someone? I'm sorry, who?
Perez, ERPC. We had a short date today.
All right, we'll see because we don't have him on the docket. Is he in custody? All right, we'll have the coordinator check and see because we don't have him on the docket. You're welcome. You don't happen to have a case number or anything, do you?
Number in last week to misdemeanor, they said they were gonna combine it to today in this room. Unless we're in the wrong room.
All right, we'll find out.
Thank you so much.
Okay. So the motions, before we go on the record, the motions, you need to come sit up here, miss.
Havana, and Your Honor, I need to correct her name. They have Havana as her last name, but it's her first name. DeJanette is her middle name.
Okay, oh, we'll get to that. Just 1 second.
Okay.
So for your motions, you have the motion for a Daubert hearing, the voluntariness of a confession, a motion in limine, and a motion to quash.
And Your Honor, we did file yesterday, and I've provided the state. I have copies
Yes.
for you, with the exception of the motion in limine. I don't.
Oh, well, I have the
The
motion in limine unless
Okay.
there's an extra motion in limine.
There is, you have that? Yeah. And then. And Your Honor, we're not doing the Daubert today. That will be after conferring with the state. They'd have asked it. We run that with testimony.
Okay.
So we're really just doing motions and limiting and the motion to quash.
Okay.
And then did you also get a copy of our memorandum?
Yes.
Okay. And then I have all copy of the quashing memorandum for you. And then
Okay.
the two other motions.
All right, thank you.
In addition, and then you said you did have the initial motion in limiting that we filed.
Well, I don't have the initial, oh, yes, I do have the initial motion in limine. Okay, that goes with that.
Your Honor, we would like to at least turn in our election of punishment and
Sure.
sworn motion to use supervision
Okay.
and trial courts.
All right, and could I have a copy of the indictment, please, in this case?
I'm sorry. I don't know if one is. That had been earlier. I did have a question about, like, did y'all ever get Shaw's video? And then on.
All right, thank you.
And that's the one that was at the pickup. Who is is it Askew? Is the one at the pickup of the dog? Yeah. Okay. I think I already have this turned in, but just to be safe.
Oh, yes, we could. Better to be economy. Yeah.
They just signed on it. without a motion and limiting, because I think y'all filed it when I wasn't. I don't think I have a copy of a motion. I mean, I know that they.
One have 3 people, 2 are males, 1 female.
All right, thank you. All right, we are going to go on the record. The court is calling 2025 CR 001454 State versus Havana Dejanay Miller. Could I have parties announced?
Lauren Espinoza and Jason Garahan for the state.
Jody Sawyers and Jared Hall as attorneys for the defendant Havana Dejanay Miller.
All right, and are you Miss Miller? All right, so we're here today to hear pretrial motions. I think it is best to start with the motion to quash, because if that were to be granted, then the other motions will not need to be heard. So the court is in receipt of the true bill of indictment, and the court is in receipt of the motion to quash the indictment and a memorandum in support of the defendant's motion to quash the indictment. State, are you prepared to proceed on the motion?
Yes, Your Honor.
All right, defense, you may proceed.
Yes, thank you, Your Honor.
Oh, you can remain seated because, and if you'll speak into the microphone, that way I can hear and the court reporter can hear.
Thank you. All right, so the issue with this statute is very specifically in regards to it's the torture provisions of 42.092. And what I mean by the torture provisions is in 42092 B1, it says that if you commit torture or in a cruel manner kill or cause serious bodily injury, that provision, we're limiting it to the torture because the state has not alleged cruel manner of death, killing, or serious bodily injury. The definition of torture is an unjustifiable, an act that causes unjustifiable pain and suffering. And while that might sound, sufficient, it's super, super vague. And it becomes even more vague when you look at the rest of the statute and how in the allowable conduct that it permits under the statute. So I do have a copy of the statute. It's actually for the court. It's actually chapter 42, most of it. It's gonna include section 4209, cruelty to livestock, and then right behind that, it's gonna include
Oh, I'm sorry, you gave me 2 copies.
okay.
I don't know, the state may need an extra one. Thank you.
Do y'all need an extra one? Okay. And then right behind that, you'll find the cruelty to non-livestock at 42.092. When you look at these statutes between livestock and non-livestock, they are identical in regards to the torture provisions. The only difference is that livestock is limited to intentionally and knowingly, whereas you have the mens rea And then non-livestock allows you to go to recklessly. So that's the only difference is the mens rea. The definition of torture under livestock, cruelty to livestock and cruelty to non-livestock is the exact same. That's important because when we look at what our society has determined is acceptable or justifiable pain and suffering, we have to understand that the context is the same regardless of whether the animal is non-livestock or livestock, even though this is pled under the non-livestock provision. Okay, then turning your attention to the actual statute of 42.092, I want to bring your attention to section B and B2. And it says a person commits an offense if the person intentionally, knowingly, or recklessly, without the owner's effective consent, kills, administers poison to, or causes serious bodily injury to an animal. So by implication, if you have the owner's effective consent, it is not illegal to kill, poison, or cause serious bodily injury to an animal. Then if you proceed downwards, it allows under B6, it allows that someone, if they have the effective owner's consent, to cause an animal bodily injury.
So are you saying that according to this part of the statute, if you are a pet owner, then you can poison your pet, you can beat your pet, and that's not a crime?
And that's what is concerning about the absurdity of this statute, but that is the statute. Basically what it's saying is if somebody else does it to your animal and you give them consent, it's okay. But read it, and that's what I'm saying. It says under B, a person commits an offense if the person intentionally, knowingly, or recklessly, without the effective consent of the owner, kills, administers poison, or causes serious bodily injury. So they can do it. It's not as long as they have the effective consent of the owner. So
Isn't that related to if you take your doctor in for veterinary care?
Well,
you euthanize, have the animal euthanized, that you're killing the animal and the owner has given consent?
And that's a great question. But if you look further, it actually has a provision that deals with the like a veterinarian services. And let me see, it is a defense on D. It is a defense under that if the actor had a reasonable fear of bodily injury, if the actor was engaged in a bona fide experimentation of scientific research, or under E, if it was discovered on the person's property, or 2, the person killed, injured the animal within the scope of the person's employment as a public servant. And then it goes on, sorry, which one is it? So I don't think that well, I think that's a great question. I don't see the actual, well, but it's a public servant. So, I mean, I don't see where it says actually a doctor, but you see what the problem there is that by saying, oh, that's just to allow a doctor, it is not limited under the statute for that purpose. It's saying anybody. And when you look at animals are considered under our statute or under our laws as chattel, as property, which is just the way our society has defined them. Whether I agree with it or I don't agree with it, the civil courts will not allow you to collect money, civil damages, for the loss of your emotional attachment to a dog. And there's a case that we have on that. It's cited in the paper. We can provide that to you. So what they do a great job of.
Well, that's civil.
I
We're
understand.
just here under the penal code.
Yes, Your Honor. And so, but the point is that the status as property is what is triggering the owner's, why you have to have the owner's effective consent, because our laws, whether they are civil or criminal, still see animals as property. They don't see them as having the same rights as a human.
But are you even with regards to this section that says without the owner's effective consent, are you arguing that you can still kill an animal in a cruel manner
I'm not arguing that. I'm saying, yes.
or cause unjustifiable pain?
So that part I am arguing with, because that is so broad as to undo all the other rights that you would have. Because when you say unjustifiable pain, does that go to emotional pain? It's not limited. It doesn't even and that's why this is going to become such an issue throughout the course of this trial, is because if, as in our case, there's no bodily injury, then you are saying that the law allows for us to criminalize acts that someone just feels cause a dog unjustifiable pain and suffering without requiring any proof of bodily injury. Humans don't even get that level of protection. You know, humans, you can't be charged for having caused someone emotional, like with a crime, for having caused them emotional injury.
Is the indictment, are you all charging this indictment as causing emotional pain to the animal?
No, Your Honor, the indictment's charging under the first section under D1 that says torture.
All right. So they're not, my understanding, and if I'm wrong, please correct me. My understanding is nobody is charging her with causing emotional pain, allegedly causing emotional pain to an animal.
So if you have no bodily injury to an animal, then what's left?
Isn't that a fact issue for the jury?
No, I don't believe so. I believe that our law will not allow, like, written as broadly as it is in conflict with every other provision that we have in our codes. Because if you look at the bodily injury, like for instance, a human assaulting another human, we specifically state in our definition of bodily injury that it is the
Causing pain?
Yeah.
Is one of them.
well, it's causing pain, but the thing is that it also it will not allow for someone to be criminally prosecuted for emotional harm or pain. And we distinguish that by saying that it has to cause bodily injury. Here, the problem with this statute is that torture provision does not require bodily pain. If anyone shows that there was no bodily injury, whether, and it's a different topic, whether you could include pain or it would require physical bodily some type of visible injury, that's a completely different issue. But just assuming for the sake of argument that if we are going to require and limit assault to bodily injury on a human, we definitely can't not require it for an animal who, under our laws, has historically and still today gets less protection. I mean, a prime example is our horse racing. We have animals that are routinely raced and beat with crops. And the reason I bring that up is because this one specifically names repeatedly striking a dog. That's the manner in which they claim. So the point is that our society has said it's justifiable to beat a horse with a hard crop for horse racing and making money, and that's justifiable.
Well, that's something that needs to be taken up with the legislature on the fact that maybe people don't want horses being beaten. I know some people complain about maybe in other countries dogs are eaten for food, but then people have a different idea of how dogs should be treated as opposed to livestock, as opposed to horses, as opposed to chickens. But that's something for the legislature to change how different animals are treated and how they're treated in sports. So my understanding, and again, if I'm wrong, correct me if I'm wrong, the state is not charging your client with emotional abuse.
No, Your Honor.
So my understanding there, the indictment doesn't mention emotional abuse. And I know you're saying torture, but my understanding from this statute and from what the state is saying, they're not charging your client with emotional abuse of an animal. They're charging her with allegedly, recklessly causing torture or committing torture.
So, first, let me back up and say that the legislature has, in their infinite wisdom, not distinguished between livestock and non-livestock for purposes of torture. And
Mhm.
so we cannot say that animals, livestock should be treated differently than non-livestock. They all are examples of what a collective class of they're a collective class. So we can't distinguish it that way. But what the problem is not whether the state sits here and tells us what they've charged. It's that the statute itself, the underlying statute, is so broad as to encompass or not eliminate the ability for someone to be convicted, including my client, of an instance in which all that happened was, if anything, emotional harm to an animal. And that's the problem with the statute. Whether the state claims that they weren't trying to, convict someone for emotional harm, it's that when we get to the end of this and that jury charge, and I go and ask the court, hey, how are you gonna keep them from convicting on emotional harm alone? The court's not gonna have an answer because the legislature didn't give us the tools.
No, here's the thing. I'm reading the indictment. The indictment is stating intentionally and knowingly, recklessly torturing an animal. Like if the state were to just have left that as says torturing an animal, I would say your client really doesn't have notice. What are they talking about? But then in the indictment, it says, namely a dog, by repeatedly striking the dog. There's no mention in this indictment about emotional harm. And whether or not you believe a jury may or may not find somebody guilty because they're thinking about emotional harm, that's something that you'll need to argue with the jury.
And Your Honor, and that's where I'm saying I have an issue with the law itself. That's why it's filed as a motion to quash, because this is something that a jury, it can't comprehend how the laws are structured in our country. I mean, they haven't studied the laws like we have as lawyers.
But isn't that what a jury charge is for? I tell them in a jury charge what the law is and they have to follow the law.
Yes, but you told them, and right now what I'm explaining is that there is no limitation on it being. So if what the court, if I'm understanding your question correctly, I think your question is, hey, can a jury convict on emotional harm? And that's the issue, because it is read that broadly. You're not going to be able to tell them no. You're not going to be able to tell them you must find at least bodily injury, however that's defined, because we as a society do not find emotional injury to be a criminal act. It would be criminalizing non-criminal conduct if we are saying you can convict on emotional harm alone. And that's the problem, is that when I ask you for the jury charge, you're not going to be able to give me a jury charge that is in line with how it is supposed to be. In my opinion, it is supposed to be limited to bodily injury, but you're not going to be able to do that because the law is absent or silent on that. And also further, if we are to say, okay, well, it's silent, we can look at, and section under Texas Penal Code 105, it tells us that we are to read these statutes, these provisions, in line with the whole context of the Texas Penal Code to be a fair interpretation of the statute. And I have a hard time believing that the legislature allows us to give effective consent for someone to cause our animal bodily injury or kill, poison, and cause serious bodily injury, but they're like, but you can't cause them emotional harm, and that it goes that far. And so what I'm saying is that if there is a way that the state could have indicted this that would have limited it and applied it the way it was probably intended to be, they would be causing that they cause bodily injury by repeatedly striking the dog, because they then, in their manner and means, have limited it and said, look, we're talking about bodily injury here. We're not talking about whether the dog was traumatized with no bodily injury.
All right, state.
Your Honor, the definition of torture, we would argue, is intentionally broad because there is a wide variety of means at which an animal can be tortured. So in this situation, in McGinnis v. State, the court focused on the words unjustifiable to conclude that yes, under the law, there are some instances where infliction of pain and suffering is allowable, which is why the state must allege specific acts that were alleging the torture occurred through. So the court in Hacker v. State as well as Cross v. State said we need to allege those specific acts as well as interpret the words unjustifiable and in that case unnecessary based on their common usage because it's not defined. The state has done that here by including the clause by repeatedly striking the animal. Further, courts, when interpreting torture, they have looked at the physical condition of the animal and the side effects of that treatment. So in Solinsky, the court found that the nature of the condition of the cats by putting them in the microwave constituted torture. And in Bell v. State, they also found torture when the defendant amputated a puppy's ears without providing anesthetic and antibiotics. Those questions, whether defense finds the torture alleged sufficient based on, pigeonholing us into proving bodily injury of the dog would be a question of fact for the finder of fact of the jury. To fix, quote unquote, fix the indictment by adding bodily injury would be adding language that's not required by statute. And we would have been here in the same position arguing against a motion to quash for adding language that isn't there. We must only prove torture, and torture is any act that causes unjustifiable pain or suffering. Even using the definition of bodily pain that defense thinks that we should have as the scope for torture in this case, it's physical pain. Pain doesn't always leave a mark. It doesn't always require physical injury for someone or something to feel pain. In McCall v. State, the appellant challenged the constitutionality of the animal cruelty statute as vague and indefinite, relying on Senator. In Senator, they found that the provision there regarding needlessly killing an animal as unconstitutional. However, the court in McCall said that the court in Senator expressly only said that one provision of needlessly killing was unconstitutional, but that the statute listed and enumerated other ways that are sufficiently definite. So by tracking the language of the statute here, we would urge that our indictment is sufficient. And then by using torture, which is under B1, and then adding the manner and means to provide adequate notice. Regarding defense's argument about property rights, we would urge to you that animals, yes, they are property and they do typically have less rights than humans, but we'd extend that to say that they need more protections because of that reason. When somebody owns property, they own it under the guise that it might involve adjustment of that rights for public good. The whole purpose of this statute is that it criminalizes an act that causes unjustifiable pain and suffering. One can't own property and not have their rights sometimes yield to the government's legitimate exercise of its power to prevent harm to the community. We would just urge, Your Honor, that the statute is not unconstitutionally vague and that any issues regarding what may or may not be torture would be a question for the jury.
All right, and defense, it's your motion, so I'll give you final argument.
Well, and Your Honor, there's other
Sure.
things that we need to address. So I would like to provide y'all with a copy of United States versus Stevens, in which the federal government dealt with a statute very similar to this one. In fact, it was more specific. It said that the statute required proof of being maimed, mutilated, and tortured. And let me see, the U.S. Supreme Court said this statute is unconstitutionally vague, and they explain why. And torture is even as defined as unjustifiable pain is even more vague, because when we look at all the ways our society allows us to put bark collars on dogs, they allow racing, with the crops, they allow branding of an animal, they allow and none of this, like when you take pigs little baby pigs. They cut their ears, and they do it deeply enough so that it can't heal again back and close back up. They pull their teeth without anesthesia. They crop their tails. They do this thing called mulesing to sheep, which they take scissors and cut off their back side so that the hair won't grow and they won't get infected. I mean, we do very, very painful things to these animals without anesthesia, and they are accepted. Museling is not illegal in the United States. And what I am afraid of is that in the United States, we feel that a parent has the right of discipline of a child, and there is no provision in here for discipline of an animal. And this statute as written is so overly broad that unjustifiable pain and suffering, I mean, unjustifiable suffering, someone might think crating your dog is unjustifiable suffering because they personally see it that way. This is so broad as to not give an ordinary citizen notice of what is actually actionable. And I would also bring the court's attention to this. Every case that I've looked at with torture has a severe degree of depravity. It is not, and it doesn't come without bodily injury. I have not found a case that has no bodily injury. And so if this statute is broad enough, because pain is so broad, pain encompasses bodily injury and emotional injury. If it's so broad, you have now allowed the jury to, because of the breadth of the statute itself, to convict for what we would consider acceptable behavior in our society: crating, leashing, bark collars are sold, shock collars, shock prods. I mean, we don't treat animals the same way that this statute is as written, the breadth of its statute could reach. Hold on one second. Yeah, and then also when you look at the term for torture, it says includes. It doesn't say is any act. So it's even more broad. They leave it so broad that I do not think an ordinary citizen can fairly know what this statute's limited to. Now, finally, what I wanted to bring the court's attention to is the very last section of our paper, of the memorandum, and it talks about whether this is a result of the conduct crime or a nature of the conduct crime. And that really matters for two reasons. One, if it's nature of the conduct, which is what the committee in their notes believed it was, then you can't recklessly engage in the nature of a conduct. And so we would ask for the recklessly to be struck. However, the committee also noted that it might be, if it's seen as a result of the conduct crime, then you have to have a result. And in here, all they did is provide the conduct. They did not limit it by giving the result that we are supposed to be defending against. And so the indictment as pled would not be sufficient under result of the conduct to proceed. And we would ask that it be quashed for that reason. There's one last thing. Hold on. Where's the motion? Sorry. And then finally, I would argue that the way the indictment is pled in and of itself shows that it's legally insufficient to be to prove torture, because it does not provide any accusation of what pain was suffered or that there was bodily pain or injury. And therefore, because all they've said is repeatedly striking, and by law, by common sense, we've seen that our society accepts horse racing and beating of horses with hard stuff, that I think that on its face, it is insufficient as pled to prove torture. It needs something more than just repeatedly striking a dog in order to constitute torture. Okay. Thank you, Your Honor.
All right, state.
Your Honor, defense keeps mentioning horses in the acts that we commit against these types of animals. However, those are livestock animals. In this case, we're dealing with non-livestock animals. These are typically in this case, cats, dogs, those kinds of things that aren't subject to the same kind of normal use and practices like a horse would be, as well as the argument about the result of conduct. She stated that we need to have a result. In this case, the result would be torture to the animal by the conduct of repeatedly striking it. And then as well, the case that was provided, I don't think is applicable here just because of the facts that we have.
All right, in the Stevens case, is that relating to First Amendment rights and the violation of First Amendment rights?
So it is a First Amendment rights case, but their interpretation of that statute as being vague is what the analysis.
But isn't it because though they were saying that it's a violation of First Amendment rights?
Well,
to
and
depict certain photos, and it wasn't necessarily about the acts against an animal. It was more about the right to free speech.
I think the bigger part of that, Your Honor, was that the statute in that case criminalized non-culpable conduct. And the court discussed that at the end when they say that this statute is so broad to even encompass, in that case, hunting videos or something that's non-culpable. The statute was so broad, similar to, what we're dealing with here, to encompass and criminalize non-culpable conduct. And I think that the issue is the same here, and that statute was even more specific than a good deal more specific than this statute.
But it's about First Amendment rights. I understand that sometimes you will have appellate courts. They will make a ruling on the issue that is specifically before them. And then you may have other members of appellate courts who will do a dissenting opinion or a consenting opinion, and then they want to add things that's not really about the issue at hand, but more as a signal to everybody to say, hey, this is what we're considering in general. But that case is about First Amendment rights and whether or not you could post videos of people being cruel to animals. Wasn't that whole statute related to the posting of videos and not necessarily about what we're here for today?
Well, in effect, that was the intent of the statute, was to ban crush videos of animals. But in practice, and when applying the statute as broadly as the court found that statute was written, it encompassed a lot more than just animal crush videos, including, like I said, hunting videos, other things that, are generally accepted practices that, we would consider non-culpable. And I think that's the bigger issue with it. It encompassed more and criminalized more conduct than necessary, without, a level of specificity to give the average person notice of, what conduct that the law is criminalizing. And I think that's what the problem was in that case. I think that's what the problem is here.
Oh. Just one moment. Let me review some law.
Your Honor, I needed to add one last thing because I do believe this also triggers First Amendment protection. While it's not.
Well, just one moment and then I'll let you say that. So with regards to the Stevens case, it appears that Congress changed the law and they made it a crime to knowingly create, sell, market, advertise, exchange, or distribute any animal crush video. And then they define what animal crush video is that depicts actual conduct in which one or more non-human animals is intentionally crushed, burned, drowned, suffocated, impaled, or otherwise subjected to serious bodily injury, and two, is obscene. So they address that. But in this case, the Stevens case, it was about First Amendment rights. And you say you want to address something with First Amendment rights here?
Yes, because conduct is also First Amendment also reaches conduct, and in this instance, there are First Amendment rights. We have a right to conduct our lives in First Amendment, like in our actions, in our words, and there are words that are taken in this instance, as well as actions that substantiate or like back up the words that are used. And she has a right to express herself, and her belief of what is right and wrong as far as discipline is protected by First Amendment. Whether we agree with that or not, someone's position, they still have the right to express themselves. And here, I do believe it's broad enough to also trigger First Amendment rights, because she's talking, she is expressing a position, and so in that regard, if you were to criminalize this, you'd also be triggering First Amendment rights of what someone believes, and it was on a video that is then publicized.
All right, what do you mean she's talking and expressing an opinion? Because I don't see that in the indictment. Is that some fact issue?
Well, it is that it reaches that, like that First Amendment is going to be triggered because she does express an opinion as to why the dog is being repeatedly struck. And so it's all in the context of.
All right, when you say express opinion, I'm trying to understand. I'm sorry for interrupting you, but I'm trying to understand your argument. When you say she's expressing an opinion, are you speaking about your client?
Yes, there is in this case, there's an opinion stated. So this case is broader than just act. It's also speech, it's conduct, and repeatedly striking is a conduct in regards to discipline. And so discipline is protected by the First Amendment. You have the right to discipline and speak your discipline and to conduct your discipline.
Okay, I'm sorry. I'm trying to understand your argument, because it appears that this is beyond the indictment, but are you saying that your client made some statements and it's protected speech?
Yes.
All right, so does that go with the voluntariness of her statement argument?
No, that is a separate.
I don't see how the court is legally allowed to go outside of the indictment when you're saying a motion to quash, because now you're bringing in facts that are not in the motion. That are not in the indictment, because nowhere in the indictment does it state that there was a film. Nowhere in the indictment does it state that your client gave statements. So it appears to the court that what you're arguing now are fact issues. If the court denies your motion, they're fact issues for the jury, not for a motion to quash.
And I understand the court's position and agree that was probably more as unconstitutional as applied argument that would be more appropriate at the end of a case than right now, when we're just looking at the face of the document of the indictment and the statute. But I would just say that repeatedly striking a dog is conduct, and conduct is protected by the First Amendment.
So you're saying striking at a dog is a form of speech?
Yes.
All right.
Because it's a form of conduct that it is by its essence related to discipline, care, control of your animal.
So then any type of conduct, be it against an animal or a human, then would be a form of speech.
It could be, but it could also not be a protected form of speech. That's possible.
All right, State, she's saying striking an animal is a form of speech and it's protected.
Your Honor, We were just asked you to look at the indictment on its face. We haven't alleged anything about discipline, anything about speech, anything about a video. We've merely alleged torture. By repeatedly striking a dog, we would assert to the court that regulation of conduct only implicates the First Amendment if it qualifies as expressive conduct akin to speech. But I don't see how it applies here, really.
All right. All right, with regards to the motion to quash, the court has heard arguments from both sides. The court has reviewed the case law that has been submitted to court. The motion to quash will be denied. All right, then the next thing, let me see. The motion in limine regarding social media and news coverage. What I can tell the parties, people always assume that I know facts about a case. I don't know any facts about the case, believe it or not. I just read a lot instead of watching a lot of news. So I'm reading your motion in limine regarding social media and news coverage. Just give me a moment. All right, so with regard to news coverage, this is what the court proposes. And if anyone has any objections, let the court know. So usually what I will do, if you all will give me some information about the case, and if you both can craft a question, because I don't know any of the facts of this case, if you can craft a question that you all both approve of, I will ask the jury if they ever heard of this case before, right? Because I don't know where this is alleged to have taken place. I don't know anything about this case. So if you all would give me a question perhaps that you all would like me to ask the jury about whether or not they've seen anything regarding this case, then I will do that. So is there any objection to that?
There's not, and that's kind of what I set out in the second paragraph is
Mhm.
kind of my hypothetical of how it might be addressed.
Yes. So if you all will confer on that, and then we can put on the record the question that you all proposed the court ask, and I'll ask that question. But if I had more alleged facts about this case, I would have a better idea of what question to ask the juror. But we can most definitely make sure that they haven't heard anything. And then if they have just stated that they've heard something, I'll question them separately.
Thank you. Yeah, that way, my concern was poisoning the jury for someone saying like everything they saw.
Okay.
And Your Honor, if I can, with the state's permission, just tell her just briefly the social media extent. Okay, so there was an alleged video taken of an incident in which it's claimed that Miss Miller struck the dog 15 to 17 times. And then it's posted all over social media. And there's been death threats, gang rape threats, and everything under that. It's been on the news. It's, I don't know, Facebook. I mean, and so my concern is just that I don't know exactly how.
Well, here's the thing. If you all get together on a question, in my mind, currently, I'm thinking just asking them, one, if they know your client, two, if they've seen any type of video in Bexar County, because I'm assuming this happened in Bexar County, because otherwise we wouldn't be here, or it's alleged to have happened in Bexar County. And I can just ask them if they are aware or have seen any videos where someone is alleged to be striking a dog.
Okay.
So that's what I'm thinking along the lines of having that. But again, if you all confer and decide on a question, we can discuss how the question is presented to the jury.
Okay. Thank you.
You're welcome. And I'll want you all to do that before you leave today.
Yes.
All right, the next thing is the first motion in limine. And it has to do with extraneous offenses or bad acts.
Yes, and specifically, what defense, well, we've filed a 404B and not received any response from the state on that. But we want to make sure that they're not mentioning, there is some reference by one of the witnesses that they had seen similar conduct before, but no details, dates, specifics have ever been given to us. And so we would want to have a hearing outside the presence of the jury before that is even mentioned.
All right, state, is there any 404B in this case?
No, Your Honor.
All right, so there will be no 404B.
Okay.
All right, and then,
There's also on that same vein, a removal hearing. And I believe that that is a separate and apart from this proceeding. They have different standards. And I don't know if it's an extraneous offense, but in regards to that removal hearing, I do not believe that the outcome of that
you mean
hearing
the removal of the
animal
Okay,
is relevant to this. So I would ask that, as I see it kind of as if it's not extraneous offense, it's definitely there. What they need for that is different from what they need here.
state, do you have any intention of bringing in evidence that the animal was removed from her care?
I think possibly, Judge, if it does become relevant throughout the course of trial.
All right, so the only potential way I see maybe it would come in is if, I don't know again about this case, unless somebody had to I know you're talking about a removal where, I believe you're talking about a removal where the animal was not returned to her.
Correct.
So removal as far as, I don't know if the animal was taken to the vet, the court considers that a different type of removal. But if you all are intending to ask any questions about the animal being permanently removed from her, then we'll need to have a hearing outside the presence of the jury. And if you think the door has been opened, we'll need to have a hearing outside the presence of the jury on that. But if you're talking about removal in that someone took the animal to a veterinarian, then that's completely different. But the legal removal, you'll all have to approach on. Does everyone understand?
Yes, and I agree with that analysis as well. We're not trying to say object to the removal to see the vet part.
Okay. All right, and then next, there's a motion in limine regarding Dr. Gottbetter.
Yes, and there's actually two, she's part of the original motion in limiting because that had to do with a Daubert, and we also have filed a Nino hearing motion now as well. But the basis of that is that the state, we filed a 702 request, and we asked specifically for the disclosure of an expert, and also 702 requires the nature of what they're going to testify to. And we did not receive any notice at all at any point from what she was going to testify to. So we object to them getting into any of that before we have a hearing outside the presence of the jury.
All right, we'll have a hearing outside the presence of the jury.
And then there's another motion in limiting that's filed more specifically to her testimony as a lay witness. So expert versus lay witness.
All right, so when you say motion in limine, I want to make sure I have your motion in limine. So I do have the general motion in limine that's titled motion in limine. And then I have the more specific motion in limine that's regarding Dr. Gottbetter.
So if number 4 on the general motion in limiting is
Mhm.
really more specifically going to the expert
Okay.
portion of her testimony. The one that was filed late last night in regards to a separate motion in limiting that just deals with her is more to her specific knowledge of the case, and our concern that it will mislead the jury. She does not see the dog until 10 days later.
Mhm.
And so telling jurors what happened or what she observes 10 days later, when we have not been provided any evidence as to where the dog was housed, who had the dog, if that can even be connected to my client, we would just want to have a hearing to see if that there's even any relevance to it, if it is overly prejudicial because of that break in time. because there is gonna be, a doctor who sees the dog within 24 hours and declares that the dog is apparently healthy. Then 10 days later, we have a doctor, got better, that comes on, sees a dog, and makes some observations that I don't know are gonna be relevant because of the break in time to whether or not what my client did to a material fact in this case.
Okay, all right, we'll have a hearing outside the presence of the jury.
Okay, thank you.
You're welcome. Does anybody have a paper clip over there?
Here, do you need one?
Yes, oh, they have one, thank you.
Okay.
Thanks. All right, then the next motion that the court has is a voluntariness of any admission or confession.
So, Your Honor, I don't know, that is not ripe right now. I did speak with the state last night, before we left, and
Mhm.
they said they're not intending to get into any statements after she was taken into custody. So unless we need to approach that, at this point, I'm not gonna
Okay,
pursue it.
all right, is there any other motion?
No, not at this time.
All right, so this is what we'll do. Norma, can you see what trials we have for the week of September 15th? And so, oh, just let me know. We'll
Oh, I
make
was like,
sure.
I have like 4 trials that week. The only reason I know it is because I have 4 trials. so-
Oh, no, let me know. The only thing is, one, I anticipate that this trial may go longer than anyone anticipates potentially. And so to start now, I don't know if that's possible. And then the first week in September, I have a judicial conference that I have to go to. And then the second week in September, the September 8th, I have jury duty. So I don't know, maybe I can be on the jury, but the judge on the jury. So so there's a visiting judge for that week. I always tell everyone, you know, you need to serve on a jury. So how would it be right for me to say, no, I'm a judge, I can't do this? So that's what I'll be doing. So
Can I ask if you're here on the week of the 22nd?
yes, I mean, I'll be here the week from the 15th through, well, for the remaining of the year. But the 22nd, you all will need to confer with Ms. Ferguson because I know we have some capital murder cases and murder trials that are up. So if you all would confer with Ms. Ferguson and Norma, the date you give them a Monday date so that we can have the hearing with regards to the expert. So we'll do the expert hearing after we have docket on Monday. So we'll do it in the afternoon.
Okay.
And so if y'all can see when your expert will be available, we'll have that in the afternoon of whatever Monday and go from there.
Judge, I was just, the only concern is just to contact our experts. Did you want us to get a specific date right now or?
Oh, if y'all want to call well, get some dates from Norma and
Okay.
then call your expert and see what Monday they're available. Or if, you know, whatever Monday they're available. Honestly, if they're available this week, we can do it this week, have a hearing. Or if they're available the week of the 15th, even though you say you have jury trials and everything, if for some reason they don't go, we can have the expert here that day.
Okay.
Would there be any objection? Because I know it's just for a hearing outside the presence of the jury. Would there be any objection to the expert for that hearing appearing by Zoom?
No, Your Honor.
All right, so that may make it easier if they can appear by Zoom.
Yes.
All right, so if you all will confer
Thank you,
Okay,
Judge.
thank you.
You're welcome. And then get a date for me, and then that will be the date.
All right. Okay, so which date are you in?
I mean, I guess it would have to be.
I can't do the 15th. I mean, I've got
Okay.
4 trials, so that, I mean, something's going. But
This week, I can't. 23rd, 24th, will be in come okay. This week I'm free,
Okay, so
but I start at 5 days next week.
9/29.
I'm sorry, questions? Yeah, I think. I don't think we want to do specifics, right? I mean, specific obviously to let you know. However, in the video, she obviously. Well, just eventually it's her. No argument.
Yeah, I mean,
You know, if they can recognize her through she. But I don't know, I mean, I know that our position is we don't want to do so specific of video. A video of a person striking the wall. I think that's so specific to the jury.
don't let them know.
Why? I think if we want to. I mean, a very broad general one would be like, if you've seen anything. Striking an animal. I'm gonna word the company, y'all speak, because that's getting bad. Look at this case.
Oh, now you just jinxed it.
Oh.
That's what everybody tells me when I say, oh, it's going to be so easy today. We're going to get out of court early. So now it's
Never say that.
it's all downhill from now.
No, I works because my husband's out of town today. He
Mhm.
flew out at 4:30 this morning and he doesn't get back until after the kids all get out of school.
Mhm.
And I was able to get both the kids to school on time, get here on time.
Mhm.
And I was like, man, everything's going well.
But I watch all of the, I think it's called 911, all of those shows, like they have 911 Texas, 911 in Los Angeles. And so I think it was 911. And so they have this, they work on their firemen. And so some new guy comes in, he's like, well, it's going to be a slow day today. They're like, why did you say that? And so they get ready down to eat, then they get another call. And then the other guy's like, I'm gonna put the lasagna in the oven. Then they get another call. And by the time they get back, the lasagna is burnt and they just keep getting calls all day. They're like, we never say it's gonna be a slow day. So do you guys have a date?
29, Connor.
Okay.
You?
Oh, I'll be here. And Norma, that's the Monday? All right, so on 9/29, we will have the Daubert hearing. That will be in the afternoon. So Norma, that'll be set at 1:30-ish. Well, 1:30-ish,
Okay.
because depends on how the morning docket goes. And then the next day, in the afternoon, we'll start with jury selection. All right.
Okay. And then Jason,
Yes.
for some reason, she's not available on 9/29.
So-
If for some reason that's her
Yeah,
available,
we're
we can
gonna
do it
put you-
beforehand.
It's a Daubert hearing for their expert.
No,
Yeah.
that's-
Exactly. I mean, I'm flexible, so
That'll
don't
be
think so.
served anyway. So that one, right?
Yeah.
Yeah, okay.
Well, I mean, I'll be physically here.
No, we will too. We'll do it in front of the judge.
All right, thank y'all.
Thank you.
And then I will.
Oh, and
get
then
back
Norma,
with
she
you
needs a
on
reset form.
Questions. I don't think she needs to
All right, thank
answer
you.
a month out, but on how she raises the question. Y'all want to do it closer in time?
That's the way it goes.
Oh, there.
Okay.
No, it's fine.
Okay.
All right, so your excuse, oh wait, I need to get the reset for you to sign. Yes.
Enough time to look at it, I'll never matter what it says, so well, but
No,
I can wait.
is it calling that?
Really, I was wondering, it's charged as a serious bodily injury, so it's a felony. Saying if there's space for lesser included for the animal cruelty, the misdemeanor A. The dog's tied up, he's on tape, he hits the dog while the dog's tied up, you can see it clear as day. I don't know if it gets to the point of serious bodily injury. Instead, the dog had bit him previously, or had bit someone previously. He said he was tying it up
Yes.
because or more put, they had called the previous day to have the dog picked up by animal. The owner did.
Yes,
It's clear in the video.
yes.
Yeah, he wanted to say.
And Jody, if they're available by Zoom and you want them to zoom in, I will let them know. Yes, if you want to do that now, we can
He's
do that
on the
now.
video.
They were.
Okay.
So
Yeah.
I can.
So-
they- one of all-
And
So I'm
he
not
also
eager
said
time.
that, yeah,
Okay.
Show up,
He's
don't
also-
show up. then I
Well-
have bigger problems.
Well, let me ask you this. So do you want to call them, have them zoom in? That way they don't have to show up
so that-
for tomorrow?
I only have, let me see how.
Yeah, they may answer to that.
UPN dot
Okay.
ESP.
I mean, if you want to do that or have them come in tomorrow at 9, either way is fine with the court.
I can get the Zoom information for tomorrow. I can get it tomorrow.
Yes.
But it's already in fact.
Yeah.
Oh, is Megan handling the animal cruelty?
No, it'll be mine, but I'm just saying, because we'll both be in the court if you want to copy us both on it.
That's right, Megan.
And then hers is gonna be M dot,
Thank you.
Yeah.
yeah.
Oh, did you already put it in?
Where did I, yes. No, right here. Oh, I was like, in mine.
All
Okay.
right, so Norma, if you can
Sign
call
here.
Attorney Baker.
Yeah. That's the same thing. So one of them, this is. Oh,
That was a, I
yeah, so this is on the 29th.
For
We
the
need to be here
expert
for the expert hearing, and then we pick the jury on the following day
the
at
Tuesday.
1:30. So you don't have to be here in the mornings, but you do have to be here in the afternoons.
But, okay, so after we pick, so I need the morning for that.
See,
Don't come in on Tuesday, it's gonna be like.
No, someone's already said they were gonna call,
who is,
not in our court,
who said they were calling?
not in our court, so when
Name-
it happens. it's
Name
gonna
names.
be-
I will do an investigation.
It'd be cold and hot. Gotta.
Yes. Who's saying they're gonna come call? I want to know, Bashan, you have, raise your right hand. Do you solemnly swear and affirm the testimony you can give? You can't take the fifth on that.
That's where the video cuts off.
I believe sometimes. Yes. I want to know who said that they were gonna change the temperature in here.
Anyone?
If the lesser included,
Okay, but Sean, that's like if somebody comes to your house as a guest
Yeah.
and they're trying to change things.
I'll have to look and see how it was filed, like under what. provision.
That's the one I never, okay. And then the other one.
Oh, Jason, could you give that to Bashan, please? Thank you.
You know what, I'm gonna.
Bashan, your hair is beautiful. Own it. So I think we're almost done for today. Do you know what song popped in my head this morning? Because of yesterday with the therapy dogs coming in, and they're so awesome. Do you all remember Brandy by the OJs?
Looks like we.
I will not sing it because then people will say, oh my gosh, why is she a judge? She should be out there singing,
Yes.
which would be a no. But you guys don't know the song Brandy? Sitting by a fireplace in my favorite dungarees. You know, I didn't know what that song was about until what? No, Brandy. So, you know, if you can tell if somebody's born in the 70s because a lot of people name their children Brandy. And so in the song, he's like playing a melody. He gets up, he walks around, he wasn't paying attention, and he didn't see her, and he tripped over her and she ran away. And then you find out that Brandy is his dog. And he doesn't know she's coming back. So the song goes, I really miss you, Brandy, missing you every day. Are you coming back home to say? Because I love you, Brandy. You know, he was sipping, you know, sitting on the front porch, sipping a cherry soda pop, building houses made of sand. So, yeah. Yeah, it was Brandy. But I like Mandy too.
Randy, I'm thinking of is the one that was Guardians of the Galaxy.
There was a Brandy in Guardians of the Galaxy. Okay, I'm not to figure out what. All right. Okay, excuse me. Did you call upstairs and say it was too cold? Did you call somebody saying it was too cold?
It was, I walk in and go, it's too cold.
Excuse me. Could you come forward for a second?
Trying to get me.
Yes. Would you raise your right hand? Do you solemnly swear and affirm?
I didn't call anybody, actually, I came to get the new date.
All right, Jason, I need you to find out who called complaining about the temperature.
My office not cold.
Oh, usually that's when they say that there's an issue with the indictment. They don't believe the indictment is, they believe the indictment is unconstitutional. So basically a motion to quash is stamping it, cancel it out. We're not proceeding because you agree with my argument. And sometimes they do that when they say a law is vague or it's unconstitutional. Believe it or not, there was a law when I was practicing that homosexual activity was a crime. It was a Class C misdemeanor. Yeah. But wow.
Hey, go in the back.
Oh my gosh.
So when I was out.
Yeah. But when I first started practicing in 1997, they had homosexual activity as a Class C misdemeanor. And so you would have clients that would be accused of indecent exposure. And then people would come over and say, hey, can we knock this down to a Class C misdemeanor? And I was like, this is insane. What is going on here? So, yeah.
Like right there in their face.
So that's one case that was recently declared, well, not recently. I would say maybe in 98 or 99, they finally took it out and said it was unconstitutional. And because they were like, why are we in people's bedrooms? And then what is it? I'm trying to think of a more recent one that was struck down, but a majority of it, it's because they say that it's vague. It doesn't put anybody on notice of what they're being charged of.
Yeah, we're gonna be arguing about the minutes.
All right, so Mr. Baker, what is happening with your client?
Well, I'm actually, we have to shoot the overflow, even if it's not accurate. So they just, you know, you don't have to object. They will go crazy.
All right, awesome. Okay. Did you complain about the cold in this courtroom?
I was on a lot of
Thank you. Trying to see, because at one point it would feel as though it was 90 degrees. We can't get a happy medium in here. Oh, thank you.
Somebody has to be the calming factor.
Yes. I would call him for any mitigation that we need.
this yesterday. I believe that he was on a PR bond, 7,500. I believe the state's not opposed to reinstating that. He had been out of custody for 2.5 years, had no trouble, no violations. He failed to show up for court. He was late that day. His lawyer said, come in by 4. And he's just honest with me. And I'll be honest with you. He said, I panicked. Because I was going to come in and get arrested, and he explained to him that happened anyway shortly thereafter, and that's what happens. He learned his lesson. Other than that, he's perfect reporting, appearing, and doing everything he's supposed to do for 2 years, and he will continue to do that.
All right. All right, come on down. All right, we're on the record in 2024 CR 5976 State versus Rodney Brown. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Very faithful, Mr. Brown.
And are you Mr. Brown?
I am.
All right, could you raise your right hand for me, please? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Rodney Brown.
All right, so why didn't you appear for court?
I woke up late and I contacted my lawyer and he told me that I had until 4. And at around like just before noon, he told me that the warrant was already issued. And to be perfectly honest, the person that I was in a relationship at the time had showed me a series of videos of your more tougher representations of the and I didn't know. I've been here the last 3 days. I came into your court, I sat in the court, and I've listened to you and talked, and it was a misrepresentation of who you are.
You can be tough. That's
I know,
what
no, I know you can be tough,
It's a
but
blitz.
the people in these videos, you know, had to be taken into consideration the context, and it was shown to me out of context. And I was during that time taking anxiety meds there, and I wasn't getting the proper care. My doctor was actually kind of a bit of a pill pusher. And so I was just going through a lot, and my family was not in a stable situation. So at the time I got nervous, and I was like, I need to take care of my family, make sure my family's good. And then once my family's good, I'm willing to turn myself in and take care of whatever needs to be taken care of. At this point, my family is in the best possible situation. So
well, what I can tell you is when I was a defense attorney, I would represent clients, and sometimes clients would say, well, I'm sitting here and this person did A, B, and C, and they're out and about. And I always have to remind them, you have to take in consideration what court they're in, what the facts of their case are, because you really don't know. And people can chop things up and make things seem different than what they are. Because I will tell you, there are some people who will come to me and they will say, just different attorneys, oh my gosh, people wearing shorts getting taken into custody. And I'm like, no. I said, that was secondary because you shouldn't wear shorts in court, but you're not allowed to take photos of or talk to inmates when you're in the gallery because for security reasons, that's not allowed. But it's easily to chop that up and thinking, oh my gosh, you're taking somebody in custody. It's just a regular citizen wearing shorts.
yes.
So there are different things that happen. But in this court, what I can tell you is hopefully I'm fair to everyone. I try to be fair to everyone. And I look at people as individuals. In each case, I don't remember people's by their numbers or case number, but I remember the person as an individual. And I remember the stories that they've told me before. That's how I remember things. And that's how I was taught to know case law, because it's easy for me to remember cases because I remember something that's sort of weird about the case and the case law. That's how I remember it. Now, sometimes I can't tell you, oh, that's Jones v. State. But when I read a little synopsis, I'm like, oh yeah, I know that case. All right. So in this court, let me just tell you, you need to come to court and you need to be on time. In this court is at 9 a.m. If it's not at 9 a.m., I will let people know, hey, we're starting at 1:30 and give people a reason. So you say that you are receiving mental health care or something, or?
I was receiving mental health care. The last time I went, I was being completely honest with her. I had a lot of stresses in my life, and I told her that the medicine wasn't working. And instead of addressing it, she just kind of switched me to another medicine that the
pharmaceutical sales rep had dropped off that day. And when I went and did some research, it was not an appropriate switch. And so I actually got myself off the medicine. I started exercising and taking a more positive outlook on life. And so I've grown a lot in the time that I've been released.
All right. And then has there been any type of drug use in the past?
No.
All right. So have you all agreed on a bond?
Yes, Your Honor, previous bond was set at $7,500.
And was that a PR bond?
It was a PR bond.
So are there going to be any objections to reinstating the PR bond?
We were asking for the bond to be made, Judge, but I know defense counsel is asking for the PR bond to be reinstated.
All right, so then the question becomes whether or not he can afford bond. I'll note that this doesn't appear to be an alleged violent offense.
That is correct. It's not a violent offense.
All right, so do you want to put any evidence on about
Sure, I will. Put my-
the amount he can afford?
Yeah, sure. Should I?
Yes.
Yeah. Well, he's been sworn. Okay. Sir, what is your current employment situation?
I'm currently unemployed, but I do have an employment opportunity as soon as I present identification.
As of right now, do you have any money in the bank, cash and savings accounts, checking accounts, CDs, or any investment accounts? Anything?
I do not.
Okay. Is it fair to say your dollar amount to your name in any holding institution is zero at this point?
It's negative.
Negative. Okay. Do you own any property?
I do not.
Okay. Do you have any? Some people might not have any money in bank, but they've got a Ford Raptor in the driveway or some other asset that they could sell to raise the $7,500. Do you have anything like that?
I do not.
What about family? Is there family that could help you to pay the $7,500 bond if the court says that?
They will not.
Okay. Do you have any other way to be able to afford that bond if the court goes?
Outside of earning the money myself, once released, if there's a way to, no.
But presently you don't.
Presently, no. I have my account for the county is in a negative, and I have $7 on my phone in order to speak to my mother. That's the only person in my life. She's on the East Coast, and she's taking care of my brothers.
She doesn't have funds either to.
No.
And you have court appointed counsel in this case. You've been by the court previously and to remain in that state at this point.
Yes.
Okay. I don't have any further questions.
All right, any questions?
Briefly, Judge. Previously to being incarcerated for the bond violation, what was your employment status before that?
I was in between jobs. I had recently been released from North Italia at the Rim, and I had applied to Hawkins Personnel Group, and they told me that if I brought in identification, a picture ID, that they would employ me.
What did they do? I'm sorry.
It's a temp agency, and they said that I could work at the Fiesta warehouse. I think it's like more downtown, Monday through Thursday. Friday is optional, it'd be overtime, and pay rate's about $15 an hour. And the only thing that stopped me from reemploying was that they did e-signature, which required a picture ID. I had my voter's registration card and my birth certificate, which should have been enough, but because of the e-signature, they told me as soon as I get ID, I'm really good.
Okay, thank you. No further questions, Judge.
All right. So this is what the court is going to do. The laws for setting bonds have changed, right? So I can either set you a bond at $3,500, or I can do the PR bond at $7,500. I'll ask that the fees are waived, and you'll have to be placed on GPS, and that'll be GPS partial for employment. Those are your only options. My hands are tied as far as.
He will take the second, Your Honor. We actually already discussed that. I forgot to mention that, but he understands that he'd be a monitor in that situation.
All right, so there's going to be a PR bond, $7,500, waive fees, and then there's going to be partial GPS for employment only. And I'll ask that the fees are waived. You do have a place to live, correct?
That would have to be verified. My plan initially was to be released to the Haven for Hope, or whenever I was released, to use my resources and not to be a further burden on my family.
All right, so this is with the GPS, he'll need to have a phone. So council, I'll need you to keep updated and let me know before, today is Wednesday, probably let me know by Friday if there's going to be an issue.
Can get a
With-
phone, no problem. I can get a phone.
But you'll have to have a specific residence.
Specific residence, I'd have to talk to him. but-
Just
Just
one
ask me to
second.
Just because I'm out, so you're.
Probation. Do y'all know, are you allowed to have GPS at Haven for Hope?
No, Your Honor. Have the full address on
Yeah.
file. Would it be-
I have a home address. My father's lived at 1543 Spring Summit.
Oh, no, you don't need to tell me the address, but I'm just letting you know you need to have a home address for GPS. And council, if you will let me know on Friday if there's an issue, we can take that up.
Okay, Judge, I will speak to him and see if I can make sure he has.
All right, and where are we on discovery? I think
Wait,
discover and offer tender.
Yes, Your Honor.
Yes, Judge, I don't intend to bring a motion on this or anything like this, but the court may recall this happened at the magistrate's court. I'm brand new to the case. I was
Yes.
appointed, okay, and no requests were made for the cameras there. There is no body cam of the arrest or anything like that for the incident we're talking about. And I believe there was the DA's representative. There are cameras at the magistrate's office, but they don't keep them this long, and we all presume that that's now been destroyed. For purposes of trial, I would like them to verify that so that I can make that argument if it's appropriate and the court allows.
All
it.
right, Norma, if you extend the plea deadline date to the third week in September, please. All right, so state, if you all can see if there's some video of this.
My understanding is it was looked into. And
Okay.
Okay.
this is a 2023 case.
Ah.
And it's been purged by now, Judge. So
Okay.
it was looked into previously. And so there is some body cams, which Mr. Baker probably just addressed about after the actual finding of, not to give you all the specific facts. Yes.
So do you need the plea deadline date extended?
Judge, that would be helpful, especially if my client ends up released. I can speak to him in better circumstances because I think we're close.
Okay.
You know?
All right, Norma, if state you have no objections to extending the plea deadline date.
No.
All right, Norma, if you can extend this for that third or either fourth week in September.
The 23rd?
All right, and make sure he has a reset form. You need to be in court at 9 a.m. Do you understand?
Yes, sir.
All right, thank you.
Referee, are you saying he's gonna be here at 1:30?
No.
our intern.
Oh, wow. Intern, meet intern. Hello, how's it going?
Good, how are you?
All right, so are you enjoying interning with probation?
I am. This is my first day.
Oh, do we need to send you on a field visit?
I don't know. I don't know if I'm ready for that yet.
She doesn't know if she's ready for the field visits. But I hope you enjoy it. So
Thank you.
is your plan, you want to be in probation or?
Probation after undergrad and then law school after.
So where are you attending school?
St. Mary's.
Oh, hi.
Yeah.
Yeah, I graduated from St. Mary's Law School.
So, yeah.
Are the fees still high?
Oh my God. They just keep getting higher.
Yeah.
They never
But
stop.
no, you'll love St. Mary's. And are you planning on going to law school at St. Mary's?
Yes. Yeah.
Yeah, I enjoyed it. I will tell you, if you don't change your mind and you're doing law school at St. Mary's,
Yeah.
join one of the, not join, but sign up for one of the clinics.
Okay.
I think they still have the civil clinic and the criminal law clinic.
Yeah.
I was in the criminal law clinic and I did it, I want to say over the summertime.
Mhm.
It was great. You get your bar card,
Yeah.
but you're a student attorney practicing under a licensed attorney,
Yeah.
but it's awesome.
I'll have to check
Yeah.
that. Yeah.
So make sure you do that.
Okay.
And then you can decide, all of my students that I teach at UTSA,
Yeah.
I always ask them what their plans are.
Okay.
And then I try to give them mentors in whatever field they think they want to be on.
Yeah.
Because the worst thing that can happen, well, not the worst, but one of the worst, it's up there,
Yeah.
is if you think you want to do something
Mhm.
and then you pay the equivalent of a mortgage
Yeah.
and then you decide that you don't like it, but you have to continue to do it
Yeah.
because you got the equivalent of a mortgage and loans.
Yeah.
So let me know when you finished if there's anybody else you want to intern with, if you want to intern with an attorney or
Okay.
intern in the DA's office.
Yeah.
Just think about what field you want to practice in, and
Yeah.
I'll see if I can set you up with somebody to intern in that specific field.
What I want to go into, I know people say have an open mind going into law school about when you want to practice, but immigration's
Oh, yeah.
is something I'm passionate about. Yeah.
Oh, yeah. Then you need to be paired with an immigration attorney
Yeah.
to see if you really want to do that.
Yeah.
If you'll leave your information with Rashawn,
Yeah.
I'll see about pairing you with an immigration attorney so you can see if you really want to do that.
That's awesome.
But I'm not taking you away from your internship. I'm not poaching. I know it's her first day. I'm not poaching, but we'll see if you can, that way you can decide if it's something that you really like, because there are some professions that you have.
Yeah.
And day in and day out, you don't see yourself getting victories.
Yeah.
And then maybe once in a blue moon, you get a victory and you're like, I can go on,
Yeah.
you know? So it's just certain things that maybe you need to see. Maybe you don't want to do an immigration once you see that. Maybe you want to do civil. Some of my students, I always, for trial advocacy, I'll have people come in and talk to them.
Yeah.
And they do different cases. And so people are like, oh, I want to be a prosecutor. I'm like, okay. So I had a prosecutor come talk to them
Yeah.
and they were showing photos from their cases. And some of them are very graphic. And some students were putting in the chat box, no, I can't do this.
Yeah. Give
And
it
I,
out.
and I told them, then you're not going to climb up the ladder if you won't do these type of cases. You will end up doing traffic tickets, which is great, but that's where you'll end up. So.
I'm excited. Yes, I'll leave my information.
Okay, awesome.
It was very nice to meet
You
you.
do, and but Sean, get her some field visits. It's good seeing you. Come by anytime if you need anything.
Thank you, Judge.
You're welcome. All right, you too. But yeah, so let me know what you're thinking about too.
Beginning judge, I had immigration
Mhm.
as well, but then I also with my major. I feel like now my kids kind of a little bit more. Now why I think like. So going into law school, I think that would be my.
Okay, well, I will tell you the thing about law school, they really don't have where you say, oh, I'm going to specialize in this. You really don't get your specialization until you graduate. But
whatever's a good day.
The only one that's close to specializing is, I want to say in patent law, you have to have a background in engineering. Yes, you have to have an engineering degree. So, yeah. So if you want to do that, then you need to, get your engineering degree, and you should probably do that. Start working on that now, if that's what you want to do. Yeah.
Moment right now, I definitely relate to what you said about knowing what
It'll be sent out.
Mhm.
and that's kind of
2019 CR.
No.
It's the organization for civil and political engagement in Kansas.
Wow.
So we tried to do like legislature advocacy. We went to the Austin for the capital
Mhm.
to advocate for menstrual equity. So I would just like telling the girls like you have to make sure you pick the major you feel like
That is
this
awesome.
be a future career, because you don't want to do 4 years of college and then get out and you just going back starting over trying to figure it out.
Like what you want to do.
Yeah.
Yes. I was in school with somebody one time. They had been an undergrad for 8 years
Wow.
because they kept switching their majors.
That's my sister right now.
Yeah.
She's currently still like not about to graduate. She's like 2 years older than me. And my mom is just like, okay,
You got to make a decision.
it's happening. Yeah.
Yeah.
So I'm not trying to do that.
Yeah.
I'm start planning it a little bit more ahead.
Oh, awesome. All right, Norma, have you talked to Mr. Baker about Cifuentes? No, at a Catholic school.
We had a bomb threat last night at UTSA.
Yes, I heard about that.
Bad. It's not like 2 days of school. Bomb threat already.
Upon notice, file a motion.
That's
Let's see the-
gonna be interesting.
Okay, great. Pretty much. I got it. Thank you.
Yeah, they say there's been a shooting at a Catholic school and 2 children are dead.
Is that in San Antonio?
No, it's in Minneapolis. That is so sad. So they say it's children aged 6 to 14. All right, so we are done for